New Mexico Real Estate Basics, page 42. Are there other issues on which a developer should be aware? All subdivisions must be developed in accordance with the Subdivision Act. Equally important is floodplain status according to Federal Emergency Management Agency, FEMA maps. In addition, the New Mexico Cultural Properties Act limits the excavation or disturbance of archaeological or burial sites. There are numerous sites like this in New Mexico, and a survey must be done to determine if development is possible and at what cost. Does New Mexico have a lead-based paint hazard reduction law? New Mexico operates under the Federal Title 10 Lead-Based Paint Poisoning Prevention Act, passed in 1992. This legislation requires notification of possible exposure to lead-based paint in all pre-1978 residential and apartment dwellings. In New Mexico, the EPA has jurisdiction over lead-based paint. Disclosure enforcement. The seller is required to notify the buyer of any known lead-based hazards and provide the buyer with any information on lead-based hazards from risk assessments or inspections in the seller's possession. The seller must also provide a booklet to the buyer or tenant. Buyers, but not tenants, have the right to have the property inspected within 10 days or any time period agreed on, or to waive this right. Failure to disclose any known presence is subject to a $10,000 fine per violation. Copies of this disclosures must be retained for 3 years. Does New Mexico require any other disclosures of environmental presence, such as asbestos and ureformaldehyde foam insulation, UFFI? No, New Mexico does not require any specific environmental disclosures. Radon testing is not required, but is a common part of residential real estate sales. New Mexico has a high incidence of natural uranium deposits. Title issues. Is New Mexico a title or lien theory state? New Mexico is a lien theory state. This means that the owner-borrower gives the lender a mortgage lien to use as collateral instead of a deed. The owner-borrower signs a promissory note as evidence of the debt and signs a mortgage lien instrument as collateral for the debt. If the owner defaults on the loan, the lender can file for judicial foreclosure on a property. In New Mexico, the owner-borrower never relinquishes legal title. How does a buyer know that title to the property is good and marketable? An abstractor or attorney examines the recorded history of the property, and this report is then given to the buyer's attorney for an opinion. Title defects discovered by the examination may then be corrected. The buyer can buy title insurance. Page 43. Once the buyer's attorney is satisfied that marketable title can be transferred, the lender proceeds with the closing. The deed is delivered and legal title passes to the purchaser. Customarily, deeds are recorded before the financing company releases the borrower's funds. Conveyance tax. Conveyance taxes Does New Mexico charge conveyance taxes? No, New Mexico does not have any conveyance taxes. Other required disclosures. What is required under residential property tax disclosure? All improved residential property transfers require the seller to disclose the amount of the property tax payable at list price. The estimate of the tax amount is made by the county assessor upon request by the seller or broker. The purchaser is required to receive this disclosure prior to becoming obligated under a contract of sale. What is a public improvement district and what disclosure is required? A public improvement district, PID, is a mechanism for finding development infrastructure. When a purchaser is buying property subject to these charges, the purchaser must receive a disclosure of all financial details. The purchaser must have no less than 7 days to review the disclosure prior to close of escrow. What are the rules regarding homeowner associations and disclosure? Homeowners associations, HOAs, are governed by contracts, memberships, or both. An HOA in which membership is mandatory and the HOA has the right to levy fines has disclosure requirements. The disclosure to prospective purchasers includes the financial status of the HOA and all rules. The purchaser must have no less than 7 days to review the disclosure prior to close of escrow.